Good evening, everyone. Thank you for joining us this evening for another webinar in our Enhanced Services webinar series. Just as a little bit of background, my name is Bill Lannis. I'm one of the directors of BC Hockey, and my portfolio involves sort of a members outreach type program, and this is part of it. We do about a dozen or so webinars a year on different topics. This particular one is called Respecting Members' Rights in Disciplinary Processes. And we have a friend of ours back on this evening. Marie-Claude Oslen has done 2 previous webinars for us. They were Managing Conflict of Interest and Disputes and Prevention Strategies. This one tonight is new to me, and I think will be a topic very good for everyone. Everyone is on mute. If you do have a question, please use the chat box, and we will monitor that over the course of the presentation. We'll also get a chance, certainly you can email BC Hockey after the presentation with your question, and we can be in touch with the presenters this evening to get answers for you. Marie will be assisted tonight by Stéphane Gregoire. Both are employees of the Sport Dispute Resolution Centre of Canada and join us tonight out of Montreal. And we're lucky to have this service, and I think the previous 2 webinars that we've done with them have been very informative and very successful. So in saying that, I'm going to turn the presentation over to Marie-Claude, and we will begin.
Thank you. Actually, Stéphane will kick this off for us. So.
Yes, hello everyone. As Bill mentioned, my name is Stéphane Grégoire. I'm the Education and Communication Coordinator here at the SDRCC. I'll just wait. Yeah, perfect. All right, so the topic for tonight, as Bill mentioned, is respecting members' rights in disciplinary processes. And I will start by giving a little overview of what the SDRCC is, what is it that we do, and so on. Marie-Claude, thank you. So the plan of the presentation tonight, so as I mentioned, an overview of the SDRCC. What are the fundamentals of discipline? We'll give a description of what's the difference between code of ethics, code of conduct. We'll also teach you how to deal with inappropriate behavior. We have some approaches that we would like to share with you. Also, how to come up with fair disciplinary process. And we're going to then entertain some questions. If you want to stay at the end of the session, we'll be entertaining some cases that have been presented to the SDRCC of some of the disciplinary issues that we had. So, Sport Dispute Resolution Centre of Canada. So, in the end of 1990s, early 2000s, athletes were constantly calling the Minister of Sport at the time, who was Denis Coderre, the last mayor of Montreal City, and he was receiving these calls from athletes that I don't know what to do, I haven't been selected to the team, this disciplinary sanction has been imposed to me, what do I do? So he put together a work group, and they came with the following problem statement. So, due to a lack of fair and consistent policies, or to the improper administration of those policies, athletes and other participants in sport are being disciplined, harassed, and denied opportunities without proper recourse to a hearing or appeal. So that's the basic fundamental of the SDRCC. If you want to switch slide. Yes. So in 2004, federal government established by a federal act the SDRCC. So we're an act of law. We're 100% not-for-profit, funded by Sport Canada. We offer prevention and resolution services to the sport community. Our resolution services are aimed at the national level, so national sports organization, national athletes, while our prevention services trickle down to all levels of sports. So it could be club members, provincial organizations like we are doing today. We currently have 59 professional arbitrators and mediators, so we provide mediation, arbitration, and resolution facilitation services to the sport community. Our services are across Canada, as you see tonight. You guys are in BC, we're in Montreal, and we also offer services in both official languages. We're also, since 2015, the designated doping tribunal in Canada. All right. Sorry, there's a little delay from the screen for me to see the slides. So at the SDRCC, we have about 45 to 50 cases a year, depending on what's going on, and about 45% of what we do is doping cases, so doping rule violations. All the rest of cases, we call these ordinary disputes. So what is an ordinary dispute? Well, you have it here on the screen. Team selection issues is a big part of what we do, so about 47% of our cases. The next biggest one is funding, so the Athletes Assistance Program, so AAP. Funding carding for athletes brings a lot of disputes to the SDRCC. And we have about 8 to 10% that are discipline related, which we're going to talk about tonight. Thank you. I'm sorry. So one of our biggest mandate at the SDRCC is to provide dispute resolution services to the sport community. Our second biggest mandate is to give education services to that same sport community. So we have kiosks that go to different conferences and events throughout Canada. We also give workshops by invitation, webinars like tonight. We also do some consultation on policy drafting, depending on the resources available at the SDRCC. Please bear in mind that we're not lawyers, so we do not give legal advice, although we can give you some feedback on some of the policy drafting. We'll talk a lot about policy drafting tonight, so if you have any questions, feel free to ask the SDRCC. Some of the topics that we cover are rights and responsibilities for athletes, negotiation skills for sport leaders, causes of disputes and risk reduction strategies. All of these topics are on our website. You'll find plenty publications on our website, publication model policies as well. We also have interactive material and appeal panel orientation module that we'll show you later in the presentation, and a mediation game if you're not familiar with what mediation is. So we're trying to make it as fun and interactive as possible. And we also come up with new publications whenever the jurisprudence of the SDRCC calls for it. So I will now getting into the topic of tonight, which is respecting team members' rights and the disciplinary processes. Sorry. Discipline. Consequences to inappropriate behavior. I want you to think about those two following questions, and we're going to try to answer these throughout the night. So, how to teach proper behavior to members? How is it that you teach behavior to members? What to do when appropriate behavior occurs as well? How do you deal with, let's say, whenever an athlete breaks a curfew or drinks during competition? How do the sanctions have to be determined? Is it something that's formal? Is it something that's informal? Depending on the situation of the organization, you may be dealing with different approaches. And just to give you an overview of all that we're going to talk about tonight, and to show the interactions between them, came up with this little pyramid. On top, you have the Code of Ethics. So there are 4 stages for implementing discipline in your organization. Code of Ethics trickles down to Code of Conduct. The Code of Conduct influences the disciplinary measures that you will be enforcing on your athletes and members of your organization. So the Code of Ethics actually trickles down to enforcing sanctions. All of these steps ensure that you will give the necessary tools to your member for them to understand how to behave, interact, and evolve within your organization and in respectful and safe environment. So the first two topics that we're going to entertain tonight are code of ethics and the code of conduct. The code of ethics is basically the basis for establishing standards of behavior. That's the basis for sound discipline policies. The code of ethics influences the code of conduct, and it's basically the backbone of the disciplinary processes. And I will now leave the floor to Marie-Claude.
Thank you, Stéphane, for this introduction. So I will move into the next slide to explain how the difference between the code of ethics and the code of conduct, and how it's important for you to recognize the differences so that that you can apply them properly. So a code of ethics would be something that would be probably applicable to the organization. So it's the ethical foundations for the operations that you have. So you're running a hockey association, and you want all of your members to abide by certain values. So it's value-based, it's general principles, it's a higher end, and sometimes it's a bit fuzzy. So this is the basis on which you will make decisions regarding discipline in the future. But it's not enough, it's too vague to really give direction to your members in terms of what you're expecting them, how you're expecting them to behave. So the code of conduct is an extension of the code of ethics, and really what it does, it translates those values that you have endorsed as an organization into the actions of your members. So how do you want your members to behave with each other and with members of other associations or other clubs? And so it's really behavior-based, and it's more concrete. So one flows, of course, the code of ethics. The code of conduct will flow from the code of ethics, and we'll show you an example of that. But here you can see that in the code of ethics, the content is fundamental values and more abstract concepts, whereas in the code of conduct, the content is expected behavior on and off the field. In terms of application, the code of ethics generally will apply to all members, so it's organizational. In the code of conduct, what's going to be useful sometimes is to have a code of conduct that's specific to athletes, or a code of conduct that's specifically for parents or for coaches or for officials. So there are different subsets of members that may have different behavior expectations depending on their role, and you want the code of conduct to be specific enough so that it addresses all of these differences. So a code of ethics without a code of conduct really is the same effect as empty words, because what you have is a bunch of very fuzzy stuff and say, oh yeah, this is great, the values of the organization, but how do I live by the values of that organization is through the code of conduct. This is a screenshot. This is an example of a code of ethics and the code of conduct that were a generic code of conduct that was developed for officials. Not in one particular sport, but there was a multi-sport context where this was developed. And if you see on the left-hand side, you have the ethical principle, and it's one of the ethical principle is dignity, and within that you have courtesy. So you treat people with courtesy, and then you ensure also as an official you're responsible for maintaining security of all participants, not just those on the field and on the ice, but also outside. But as an official, your role is to maintain dignity of the participants. And how it translates into the code of conduct is a more pointy things, where you have, so I'm going to try to, I have something on my screen that hides what I'm supposed to be seeing. There we go. So for example, communicate in a respectful manner with other participants. That's very general. So what I'm saying in the code of conduct is show consideration and politeness and use appropriate language, create a context that is conducive to courteous dialogue, and act with moderation and objectivity. So you just see how already like the code of conduct is more concrete, and it tells people how to behave. The second page of that goes to the ethical principle of integrity, and it's all that respect of the rules. Like the first one was respect of participants, respect of other people, and the second aspect of it is respect of the rule. So only the athlete's performance will dictate the outcome of the competition. That's the general integrity concept. And then the values that are associated with that are competence, fair play, and authority. So hopefully that gives you a good image of the difference between code of ethics and code of conduct. So we're going to talk more specifically about a code of conduct, because in building that code of conduct, you also have important decisions to make. The disciplinary measures need to be based on legal power, and for that you need to have a code of conduct in your organization. And I'll give you an example of an organization that contacted me a few years ago. It was a table tennis club, and they had expelled a member, an athlete, from the club for doing something really inappropriate, and the parents of that athlete threatened to sue the club and go to civil court to sue them because they had no right to expel him from the club. And the first question I asked the person from the club who called me about the situation, I said, well, do you have a code of conduct? And there was dead silence at the other end of the phone call. They didn't have a code of conduct. So they had no athlete agreement. They had no legal power to say, you breached a code of conduct, and as a consequence of breaching that code, we're expelling you from the club because we don't want that kind of behavior. So it's important for them. Had they gone to civil courts with that situation, the club would probably have lost the case. They had to take the kid back in, but I'm sure they organized themselves afterwards to have a code of conduct. So it's important to have one. You set out the standard of behavior. There's two ways you could do this. There's the positive wording and there's the negative wording. And the positive one is expectations and model behavior. And this is how we want our participants and our members to behave. And then there's the negative one. And sometimes we see it where the code of conduct is written as a thou shalt not. It's everything you can't do. And sometimes what happens if you have the negative version is that if you forget to name something and that person does it and everybody thinks it's inappropriate, but it's not in the code, you're stuck. You can't do anything with it. Whereas if you're looking for the positive behavior, a failure of abiding by that code of conduct is a breach. Whereas in the negative version, doing something is a breach of the code of conduct because it says you can't do these things. The way that we deal with deviations also is different, because if the code is worded in a positive model behavior format, then one-time breach could lead to a sanction depending on the severity, depending on the circumstances. But then you have a repeat offense and it's going to equate to a sanction, and slips may be forgiven. Whereas if you have deviations in a thou shalt not, well, it's a clear breach. They've done something that was forbidden, and there has to be a sanction no matter what the circumstances were, and you have an obligation to sanction. So it ties your hands a little bit to deal with things that people may do sometimes not having time to think about what they're doing, under some pressure, not realizing the impact of their behavior. And especially with young kids, sometimes, you have to tell them a couple times that they can't do this before they realize that they shouldn't. So the positive wording gives you more flexibility or discretion. And of course, the negative wording gives you less flexibility or discretion. So in some cases, you may prefer the negative. That's okay. We do encourage the positive just because it provides you with more flexibility. And we'll talk about the disciplinary process, which is how you're going to decide what sanctions will flow from the inappropriate behavior. So this is an example of when I showed to you earlier the code of ethics and the code of conduct that was built for officials. And this is guys in Quebec. And what they've done is they've taken the model code of ethics and code of conduct, and they translated it into things that were more meaningful and more using their language. So if you look at the top one, is the judge respects the competition rules and directives from event organizers as well as those of the meets referee. So they really talk the language of the diving officials, but at the same time, they're using the same principle, which is apply all rules in a just and uniform manner, respect policies and procedures so as to foster a climate of equity. So they're telling people, these are the things we want you to do, and it's a positive wording. This is what you do. This is what we expect you to do. So if there's a breach of that, there's always room to say, okay, what happened that caused you to not respect this code of conduct? And then you have room to be more lenient if there are extenuating circumstances where maybe the directives were not, from the event organizer, were not followed, but the judge was actually mindful of the security of participants rather than applying the rules very strictly. So you have more leeway to recognize the specific circumstances under which the breach took place. And then you can abide accordingly. So now what? We have an inappropriate behavior that occurred, and we need to deal with it. So there has to be consequences, of course, to the inappropriate behavior. So a code of conduct without sanction has the same effect as empty words, because you can have something on paper and it's really nice, but if there's never any consequences to members who keep breaching the code, then you're telling people that the code of conduct has absolutely no value, and it just sits there as a document. So how do you actually apply sanctions and enforce sanctions onto your members who breach the code of conduct? So there's two ways you could do this. The first one is the informal approach, and the second one is the formal approach. And the formal approach is very time-consuming and more complicated than the informal approach. So what we suggest is that there be room to do the informal approach first, and if necessary, then move into the more formal. So for example, this informal approach, if you see someone do something that's not correct or not acceptable in the eyes of the organization, you can make a verbal comment to them, and you can say, did you know that this is not permitted in our organization to do something like that? And the second time could be a private discussion with the member in person. So we'll actually sit down and we'll have a talk. There may be someone else in the room with you, and you're going to be having that discussion a little more seriously. This is something that we do not want. The other informal approach is also a written warning. This is the last time we tell you that we don't want that kind of behavior in our organization. And with, next time this happens, there will be sanctions. So the formal approach kicks in at that point where you're actually willing to impose sanctions, but you have to have a disciplinary process. And this is what I meant when I said it's a little more complicated, because if you want to have a disciplinary process, you have to make sure that it's fair and it's properly conducted and it respects the rules of natural justice. So we'll talk about those rules of natural justice later in the presentation. So I'm showing you a possible classification of breaches here, because you can have minor breaches where the first time it happens, it's going to be the informal approach. And the second breach for a minor infraction is going to be the informal approach with a written notice. And then, if they haven't learned the first two times, then you kick in the formal approach, which will imply a disciplinary hearing and possibly sanctions. Whereas some breaches can be serious and deserve a formal approach right from the start. As soon as you see it happening, it needs to be addressed. So it's for you to decide within the code of conduct that you will develop what you consider to be a serious breach that deserves the formal approach right from the get-go, or a minor breach of the code of conduct. So on a right-hand side, and this table is not necessarily fixed in concrete. You adapt it, but it's just to show you how you can actually deal with different situations. So it's possible that certain serious breaches, right from the second breach, will be a formal post with permanent consequence, which could be being expelled from the organization. But it's malleable. You have to decide where each breach of the code of conduct fits in, and at one point do you want the formal approach with permanent consequences to kick in. All right, we'll talk a little bit about reinforcing the message, because what we do here is prevention of disputes. So what we think we can do also is to prevent breaches of the code of conduct by your members. So first of all, I would say that before getting into the extra disciplinary measures, I just want to say it is important also that your members are aware that there's a code of conduct, that there's a certain behavior that is expected of them. This could be done by making your code of conduct public, and this is easy nowadays with communication means that you have. Make it public. This is also something that members can sign on to when they become a member, of a team, or even you can have the parents. It's a mandatory process for their kids to be on one of the teams in your organization, is to sign that code of conduct for parents. So if you have a process that makes them think about, oh, okay, yes, so I'm signing on to this, and if I don't respect it, there may be some consequences. So it is important that the members know, and not only know that it exists, but they also have an active, a proactive way of committing to respecting those code of conduct. And it's easier also when you need to enforce these things, when you can prove that the person actually signed the document, because whether or not they read it before they signed, because they posed their signature at the bottom of the document, they're bound by it. So we're going to talk about extradisciplinary measures, because I think it's important in any sport organization to reward good behavior, because it shows to the others that you really care about the code of conduct being respected. So you inform your new members of the code of conduct, and you do some orientation and training. You get your coaches to make sure that the athletes on the team and the parents on the team are aware of what's allowed, what's not allowed, and what can bring about consequences. So get the buy-in and the sign-off for them. There's other ways to reward good behavior, is also to congratulate publicly the good deeds by your members. So it could be on social media or in a newsletter. You can recognize the good things that your members have done, and you want to recognize that they're model members. And you can offer perks for members with impeccable records. So you can have a point system, you can have rebate on membership fees, and so there's different ways that you can reward that good behavior, and not just wait until something bad happens before you actually make an example out of someone. I mean, the point system thing, I just want to give an example. I don't know if some of you may be familiar in Quebec. There's a fair play point system in minor hockey, where they implemented that a long time ago, but they actually awarded fair play points to teams for each game that was played. And if you had a certain number of penalties during the game, you would lose your fair play point. But the fair play point that you were given to start the game with, they were added to the win-lose record. So you could lose the game, but your athletes would be on good behavior during the game, and you would still have points in the ranking for the teams. So that was a point system that was there to reward good behavior, because it was not penalizing the teams. It was giving them their points, assuming you're going to be on your good behavior, and this is what you get. But if you do not act properly on the ice, or you get major penalties or something, then you lose your points. So it was an extra incentive for the athletes and for the coaches to be on their best behavior during games, because it actually sometimes it paid off more to play the game and be sorry, I'm I'm losing my English, but it was paying off for them to be to conduct themselves properly on the ice, more than winning games. And you can create an award that recognizes role models and not just those that score more goals and win more games, but you can have an award for those who show impeccable behavior on ice and off the ice. All right, we're going to come back to dealing with the breach here, so because that's what we're talking about here, disciplinary processes. So there are two options for you defining the way in which you will deal with the breach. And I don't think there's one that's better than the other, but for sure you can't go without both of them. So the first option is that the code of conduct will actually define the disciplinary process that's going to be followed when there is a breach that calls for a formal approach. And sometimes you'll have a disciplinary policy that's going to be separate from the code of conduct, but then any code of conduct breach will then have to be addressed using this other policy, which is a separate one, so it refers to it. So certainly the code should establish, as we talked about earlier, the expected behavior and the consequences of breaches. But then you also have to have the process to follow to deal with breaches, who has the authority to impose a sanction, and the general timelines for a timely process. This is option one, where you have the disciplinary procedure will be established within the code of conduct. The other option is that you have the expected behavior and the consequences of breaches that are worked into the code of conduct. And then you have a disciplinary policy that would establish the process to be followed to deal with breaches, who has the authority to impose a sanction, and general timelines for a timely process. So those would be the two options that you would have. If you have several codes of conduct, for example, one for parents, one for coaches, one for athletes, one for officials and others, one for board members, you could have a code of conduct for board members as well. Then the disciplinary policy could be a standalone document that would deal with breaches of any of the code of conduct, instead of having to repeat the disciplinary process in 4 or 5 different documents. So prior to being sanctioned, the person who breached the code of conduct has a right to a hearing, and the right to a hearing means that you have to be informed, and these are the principles of natural justice that we talked about earlier. The members, you have to inform the members of the allegation. So what is it that they're accused of, and what was the incident that are considered to be a breach of the code of conduct? And you have to inform them fully. So they need to know who made the complaint and on under what circumstances, and have the information, the evidence, the proof that people are going to put forward to prove that they breached the code of conduct. If there's any video file or anything, they should have that before they go to a hearing so that they can defend themselves. I have a quick example. Again, it's a hockey example, where there was an official, a young official, a minor actually, who was called before a discipline committee because there had been a complaint against that official from one of the games. But the official was convened to a disciplinary hearing in front of that committee, not knowing what was going on. So he was just told to show up that evening at that place, and then the committee wanted to meet with him. The problem was that they didn't inform him of why they wanted to meet with him. So he came to the meeting completely unprepared. He found out on site what event had caused the complaint. He had refereed probably 10 or 15 games since then. So he didn't, his recollection of the events were a bit fuzzy. Had he known before that the meeting was about an incident that took place on the games 2 weeks ago, he might have looked in his referee book and maybe, a copy of the game sheet or something to try to remember what happened in that game, where the event was and so on. And maybe there were other people in the stands who were witness to what happened, and he could have brought them with him as witnesses to corroborate his version of the facts. But he showed up alone. On top of that, he was a minor, and his parents were never invited to attend, and he was not asked to bring a representative, which is improper in Canada. You can't do that. You have a right to a representative, and minors should always be represented by an authorized adult in a disciplinary process. So just to say, don't do that. So give an opportunity to reply to the allegations and the right to bring a representative at the hearing, and a right to a fair hearing. And the right to a fair hearing also includes having people who are going to decide that are independent, and they don't have a stake in the outcome of you being sanctioned or not sanctioned. And I want to open a little parenthesis on this one, because if you are the person against whom the breach took place, so if you were, for example, if you're the coach and you want one of your athletes to be disciplined because they acted improperly towards you, you should not be on the panel deciding what the sanction will be, because it's not fair, because you're the victim, and the victim cannot sit as a judge. So the right to a fair hearing, you ensure that there are 1, 2, or 3 people who are going to make that decision, that decision about the sanction, that don't have a personal stake or otherwise in the outcome of the disciplinary hearing. The right to a timely hearing is important as well. You don't want things to drag on longer than need to, but the timely hearing is also extremely important if you have an athlete or a coach or someone who is provisionally suspended until there's a decision made on the case. So you can't drag this on forever, because you're causing a prejudice to that person by not acting quickly. So if there's any provision in your code of conduct that says that if this happens, you're suspended until there's a hearing to deal with it, then have the hearing as soon as possible. And if that person is then suspended for a longer period of time, they'll serve that sentence. But you don't want to have a suspension, provisional suspension that lasts for a long time until you deal with the issue, and then you find out that the person should not have been suspended in the first place. And you have a right to a decision with reasons, and that means if you're being told that you actually breached the code and you're going to be sanctioned, then you have a right to a decision that explains why and how the committee interpreted your actions as being a breach, and why they decided on the sanction that they decided on. All right, we're getting there. Sanctions without enforcement have the same effect as empty words. Well, of course, if you suspend someone and you let them play, why would you have gone through the trouble of having a code of ethics and a code of conduct and a disciplinary process, and in the end the person gets away with not having to abide by the sanction because nobody monitors it? So it's important for you to have a way to ensure that the sanctions are enforced when they are imposed. So we're coming back to this code of ethics, code of conduct, and we showed you at the beginning of the presentation, Stefan talked about this. So this is really what we're proposing that you do, is make sure you have a code of ethics that outlines the values of the organization and the principles on which you want the members to behave. And then the code of conduct will give them, what does this mean for me on a day-to-day basis? How am I supposed to behave in order to meet the standards of the organization? And then if there's a breach of that, you have to have proper disciplinary measures through a disciplinary policy and a proper hearing process before you can enforce the sanctions that are eventually going to be imposed. So I'm going to leave the floor back to Stefan, who's going to talk to you a little bit about the appeal panel orientation, and we're going to wrap up. And for those who are able to stay a little longer, we'll go through some of these SDRCC real cases to show you what's happened to them. So,
Marie-Claude, I did have one question that came in, and I just wondered if you could address it. And it's about our referee on ice calls, where we do not give the player the report. We only tell them what the call was. And so we institute a sanction that really cuts a few corners, I think, on the process that you've laid out. But it certainly does simplify it in a sort of timely fashion.
Mm-hmm. So it's an automatic sanction based on the call of the referee?
Correct.
Okay, but that I think I see where this is coming, but normally the referee's decision is not appealable. This is an on-ice call unless you have a protest policy that allows a coach to file a protest on a call of an official. Some sports have it as part of their rules that someone can file a protest on a judge or on a referee call. I don't know if you have that in your organization, but if it's an on the field, on the ice call, it's part of the rules of the game, right? It's the rule of the game. It's not a behavior outside of the ice, or a behavior that has nothing to do with the game itself being played. Is that clear? Is that not clear?
Yeah, I think that's certainly clearer in my mind, and I think that will suffice for now, and we can follow up on that if necessary.
There's an interesting decision, a recent decision. It's probably still on our homepage on our website, and it's regarding Football Canada. And there was an incident in a game. I think it was the Canada Cup, and one of the players. But the thing is, the official on the field did not make the call, and everybody thought that the official should have. So they went into a disciplinary process of some sort, which in the end the arbitrator determined that it was in breach of the disciplinary policy. But the fact that the official on the game had not made that call caused a lot of headaches for the organizer of the tournament to then take action against the player. If someone is serious, you can go and read that document. But it's not one of the examples that we're giving today. It's not one of the three cases that we'll talk about, but that it sort of ties into a little more closely to the question, because it deals with what the authority of the official and what the official can and cannot rule on. And if your rules say that a certain type of behavior, or if the penalty is called by the official, it's an automatic suspension for 1 or 2 games or whatever, then I'd say it's part of the game. It's part of me, calling a blue line, and maybe I missed the blue line. Maybe it wasn't offside, but I called it, and there's no goal, and you can't change that. So it's a call by the official. And again, you can let me know if there's a protest opportunity for teams on those types of things. I don't know if there are.
I think you've answered the question in enough detail.
Perfect. Okay, so I'll let Stefan then talk about the online internal appeal panel orientation and what it can do in terms of disciplinary processes.
All right. So in terms of the online internal appeal panel orientation, this is, as I said earlier in the presentation, an interactive module that we have on our website. You can access it through our publications page on the SDRCC website. So basically, it's composed of 5 main units. These units talk about the fairness in decision-making, case management, the hearing, the decision, and the human factor. So it takes about 40 minutes, 40 to 45 minutes for you to complete this module. You can start it and drop it, pick it up whenever. So throughout this interactive panel, you will have toolboxes with relevant tools that you will need for how to conduct a hearing, or what are the best practices to manage a case. So let's say you have a case, a disciplinary case. So how do you deal with documents? How do you deal with witnesses? The contact information of all the participants. Also, how do you come up with a decision, reasoned decision? So what are the key aspects to integrate in the decision? And one of the also very important units of this interactive module, sorry, is how to deal with the human factor. So the stress of the people that show up to a disciplinary hearing, or some of the anger management, tactics that you can use to de-escalate the situation a bit. So with this, it's for internal appeal, but you can apply it to disciplinary processes for sure. It's very adaptable, and as I mentioned, if you have any questions throughout the module, you also always have like a toolbox to click on it and have relevant information. If you need any assistance from the SDRCC, feel free to let us know as well. And you can also, as I mentioned, you can download those documents throughout the course, and so it's a great step for volunteers that have no legal background. It will show you the principles of what are the principles of natural justice, how do they apply during a hearing, what are the key elements to consider. So it's very helpful for people that have no legal background, especially since organizations are usually composed of volunteers. Did you have anything to add?
No, that was well explained. Thank you. Right, so we're going to go into the last disciplinary cases at the SDRCC. And Stefan, I don't know if there's 1 or 2 of the cases that you want to present.
I would go with the working one. You want to start with Lisa, maybe? I don't mind doing Lisa as well.
I didn't see a text from you that you wanted to do one of them.
Oh, I sent it to you, but I'll go with Lisa. I don't mind.
Okay, all right. So go ahead.
I'll try to do my best. Bear with me. It's the first time that I present these cases. So, Marc-Claude, if you have any comments, jump in. Don't mind. All right. So this case happened in 2013. So basically, it deals with a elite junior age fencer that was not selected to participate at the 2014 Junior Pan Am Championships. And in order to get to those Junior Pan Am Championships, you needed to be on the high performance program. The federation decided not to nominate him because they alleged that he violated the code of conduct while on a competition for the World Junior Championships that were in Croatia in April the same year, so in 2013. He broke the curfew twice and didn't inform the weapon leader at the time, which was mandatory. So he was punished on site for his behavior. The weapon leader said that the athlete would be sent home. It was verbally advised that in the event of it was verbally advised that in the event of a further breach, then a formal sanction would be imposed. So as I mentioned, he would be sent home. So after a third curfew breach, the athlete was advised that he would be removed from the event, and he would be sent home. But his father objected to this sanction because he argued that it was not in the consequences listed in the code of conduct. So then there you see that in the code of conduct, so you have specific guidelines that you need to follow for behavior, and the list of consequences for in competition. The sending athletes home was not part of it. So the athlete remained in Croatia and returned to Canada as initially scheduled. So that happened in April of 2013. Then the athlete was informed in November of 2013 by the weapon leader again that he would recommend not to add him to the high performance program. That decision was later confirmed by the high performance advisory committee. The athlete appealed the decision at the SDICC because the federation did not advise him until months later that he would not be eligible, and he already had consequences during the junior championship. He was not able to finish the competition. He was not informed at the time, and in a timely manner, that there would be further consequences. So they breached the arbitrator ruled that they breached the rules of natural justice because he was not informed in a timely manner, and he was also not convened to any sort of hearing to defend his case. So high performance program sanction was not communicated until months later. So, but they said that other sanctions may apply because sanctions may be punctual but cannot be imposed months after the events without any notice. So this case shows how reasonable delays have to be taken into consideration. So basically, the arbitrator ruled that he ordered the federation to add the athlete to the high performance program. So that made him eligible for the Junior Pan Am Championships. As I said, because the HPP sanction was not communicated until months later after the sanction was imposed.
So that particular case, just to round up that particular case, the federation decided to keep this issue that occurred many months before over the head of the athlete forever, and it's like they were just waiting to drop the guillotine on him anytime. They were just they waited for the right moment, and it was beyond what the code of conduct was planning. I mean, this athlete was obviously not a sweetheart, but it was the arbitrator didn't agree with the federation for sanctioning him for his actions several months ago, and then saying and further sanctions may apply, and then leave the door open, and then nail him many months later with, oh, by the way, we're not going to add you to the high performance program because of what you did several months ago. So the arbitrator certainly didn't like that approach. Okay, so I'm going to talk about Stadnik and Bowles, Canada. So Stadnik, again, not necessarily a sweetheart. He was on the national team for several years. He was a very talented athlete. I think his brother was also on the team with him. And he was unruly. He was, I think he was drinking. He was bad-mouthing the national team committee. And some of that was done by email as well. So in the end, he wasn't necessarily an easy athlete to deal with. The problem that happened when the national team committee decided to kick him off the team for a year is that in reading the athlete agreement, they weren't the proper authority to make that decision, because if you read the athlete agreement, only the board of directors was entitled to suspend athletes or expel athletes from the national team. The national team committee did not have that authority, so they actually made a decision that they did not have that authority to make. He also, the arbitrator thought that the sanction was disproportionate to the actions of the athletes, And because the behavior, or a part of the behavior that was offensive, was actually directed at the national team committee, the arbitrator said, you can't be the decision maker because you're in conflict of interest, because you're the victim of that behavior. So this is what I was talking about earlier, about the importance that if the bad behavior that needs to be corrected is directed at you, then you shouldn't be the one making that decision, because that puts you in conflict of interest. And it's also very important to follow the policies that are then the way they are written, because you know, if you don't have the authority to impose a certain sanction, then you want to pass this authority on to someone else who can. And then that's going to be the last case. We're going to wrap this up within an hour. I think Bill's going to be happy. So Worthen and Team Nova Scotia, that happened at Canada Games. And the coach, Worthen was a coach, and he went the night before the closing ceremonies, went to have a few drinks with friends, and he was out, and that was in Whitehorse, Yukon, and when it was time for him to come back to the village, he called a cab. Didn't realize, this coach, that calling a cab past midnight in Whitehorse, you can wait for a long, long time for that cab to arrive. And that's what happened. He waited and waited, and he couldn't find a ride back. And so he ended up breaching the curfew, not because he purposely missed the curfew or decided to stay out later, but you know, by lack of knowledge about taxi services in Whitehorse late night. So in the end, the team sanctioned him to not participate in the closing ceremony, and he appealed that decision to the SDRCC, and the arbitrator's ruling canceled the committee's sanction. He received a verbal warning for having breached the code of conduct for the team, but the arbitrator felt that the committee had failed to take into consideration relevant factors, which is that the coach did not deny that he breached the curfew. He admitted the violation. He was remorseful, and he made several attempts to return to his residence, and that was that could be shown through phone calls that he had made to try to get a ride to come back to the village. So the arbitrator thought, again, that the sanction was disproportionate based on the fact that the breach was not intentional, and certainly there were efforts made on the part of the coach to avoid the breach. So that's our third example. And other decisions overturned by the SDRCC arbitrators been because the sanction was communicated too late. The policy is unclear about who has the authority to impose a sanction. Disciplinary committee was biased. The sanction is disproportionate. The decision is based on a relevant factor or disregarding significant facts, or because sometimes no disciplinary hearing was held altogether. So this concludes our presentation. Happy holidays, everybody. We're happy to entertain some questions if there's time for it.
Thanks, Marie-Claude and Stefan. Always our pleasure to have you visit us, even if it's via conference. I'm always amazed at what I don't know about this sport, and how we need to behave and how we need to conduct our business. And I love dealing with people that are specialists in their field and can assist us. And I would encourage everyone to take a look at the Sport Dispute Resolution website and go through some of their resources and some of their courses. They will help. They are there for that, and properly positioned, they will help your organization. On behalf of BC Hockey and our presenters tonight, thank you very much for attending. We're coming up to a pretty special time of year. I encourage you to get out and watch some kids play the game, and it's just simply good for the soul. And I hope everyone has a very Merry Christmas and a real good time with family and friends, and hopefully a little bit of time in there for the game of hockey. So in saying that, thank you very much, everybody, and we'll conclude this evening's presentation. If you do have questions, you can forward them to info@bchockey.net, and we will do our best to get those questions answered for you. And a copy of this presentation will be posted on our website, on the BC Hockey website, in a couple days' time, and available for those that maybe weren't available for this evening. So that's another sort of great resource that a presentation like this will leave behind. So thank you, everyone. Marie, Stefan, thank you very, very much, and we will hopefully invite you to another webinar in the very near future. Good night, everyone.
Thank you for organizing. Thank you.
Thank you for organizing.
Good night, everyone.